So let's get started with today's topic, that is judicial review. So the question is, in India, it is asking us specifically about India. In India, judicial review implies A. The power of the judiciary to pronounce upon the constitutionality of laws and executive orders. Option A. Option B. The power of the judiciary to question the wisdoms of the laws enacted by the legislatures. Option C. The power of the judiciary to review all the legislative enactments before they are assented to by the President. And option D. The power of the judiciary to review its own judgments given earlier in similar or different cases. So we will have a quick revision about what judicial review is. Judicial review, in fact, is the power of the higher judiciary to declare a law that has been passed by legislature as well as that of executive, that is through executive orders, to be unconstitutional as well as void if it violates one or more provisions that has been enlisted by the Constitution. So basically, judicial review is the power of the judiciary, especially the higher judiciary, in fact. So it is the power of the higher judiciary to declare a law that has been passed by legislature, both legislature as well as executive, as unconstitutional and void if it seeks or if it violates one or more provisions of the Constitution. And in fact, you can see this in Article 13 of Part 3 of our Constitution. That is, it says that any laws that has been brought which violates our fundamental rights will be declared null and void. So that Article 13, along with that Article 32, that is right to constitutional remedies, which ensures that Supreme Court can be directly approached by a citizen if his fundamental rights has been violated by the executive or the legislature. And also Article 226 that deals at the High Court level. So basically we can say these three articles, it actually shows that judicial review is actually a basic structure of our Constitution. But it is subjected to two conditions. Basically, if there is two interpretations for a law that has been passed, in such a case, the interpretation which seeks or the interpretation which leads to the validation of that particular law would be accepted by the judiciary. So, would be preferred by the judiciary, thereby saying that that particular law is constitutional. So, that is one particular criteria. The second one is that it can be used only before or only after, only after a law comes into force. So, basically you can see that when NJC Act was passed, well before it, a plea was brought before the Supreme Court, where the Supreme Court declined the plea, saying that the act that particular bill, at that particular time NJC was a bill. So, let the bill pass, only after that is bill pass and let it become an act, only then the Supreme Court will be reviewing that particular act, and accordingly Supreme Court has reviewed it and has struck down it as unconstitutional. So basically that shows that only when a law, only when a law comes into force, it can be subjected to judicial review. So along with that, so what is exactly the benefits of having this judicial review? First and foremost, it ensures or it maintains the supremacy of our Constitution. So that is particularly the most important part. Second important part is that it also ensures there is a division of power as well as maintains the balance between the three organs of our Constitution, or of our state, in fact. That is the balance between judiciary, executive as well as legislature. And more than that, it seeks to secure the rule of law. The rule of law, which is one of the basic structure of our Constitution. It seeks to ensure secure this rule of law through this judicial review. It also seeks to safeguard the rights of individuals and also maintains the independence of the judiciary. So that is what judicial review or the benefits of judicial review are. So basically, let's come back to the question. In India, judicial review implies the power of judiciary to pronounce upon the constitutionality of laws and executive order. So that is a particular first statement. Second one, the power of judiciary to question the wisdom of laws enacted by the legislature. So it is not, so we can say that the wisdom, etc., it is not looking into the wisdom, it would be looking whether it is constitutional, that is, it is in accordance with the provisions of the Constitution. So this wisdom can be ruled out. C, the power of the judiciary to review all the legislative enactments before they are assented to by the President. In fact, this is a blunder, in fact, so that's the reason why we can eliminate it then and there itself. And also the D, option D, Delhi, that is the power of the judiciary to review its own judgments given earlier in similar or different cases. So the power of judiciary to review its own judgment, etc., comes under revisionary jurisdiction. So which means that option D can also be eliminated. So basically, the answer should be option A, the power of the judiciary to pronounce upon the constitutionality of laws that has been passed both by legislature as well as through executive orders. So that's it. Thank you.